This is WPSL Port St. Lucie, the talk of the Treasure Coast.
The opinions on this program are those of the program host and guest and not necessarily those of WPSL. WPSL does not endorse products that may be mentioned. Any reproduction or retransmission of this broadcast is strictly prohibited without written consent of WPSL. Legal questions? Ask a lawyer. Give us a call at 340-1590, 340-1590 here at the studios of WPSL. And Ask a Lawyer with your host, attorney Stuart M. Address.
Good morning, everybody. It's Friday at 10:05, so it's time for Ask a Lawyer. Don't be confused by last week. We had an episode of Ask a Rabbi. That's because I was lying on my couch yelling and screaming in pain, but hopefully that won't happen much more often. I'm dealing with a little hip issue. So we are back to Ask a Lawyer today, and what we're going to do is discuss sort of the ending of our chat about wage and hour, and then we're going to move into another area, which is non-compete agreements when you are starting a new job, and what happens when you want to leave that job. So obviously you folks can call in with any question you have. Doesn't have to be on these topics. Matter of fact, bring me to another area, and who knows, we may stay there for an hour. So it's 340-1590. Give us a call, and I hope you enjoyed our little interlude of last week. I hear it went very well. And thank you to Rabbi Shafir Loeb of Congregation Eitz Chaim in Port St. Lucie. She did very well for me on about 45 minutes notice when I said there is no way I'm getting there. All right, so, by the way, folks, I have a little guest in the room with me today. He's now smirking and getting a little bit of a redness around his face. Is looking and thinking, Dad, why are you doing this? I have my son with me since it is spring break here in St. Lucie County. Aaron, say hello to everybody in Radio Land.
What's up?
That's what you get from a 14-year-old. All right, so we were talking for a couple weeks on and off about overtime and minimum wage and who's exempt and who's non-exempt. I just want to cover with you one more category of exemptions, then talk a little bit about some other issues, and then we'll move out of that area, which of course doesn't mean that if you got a problem next week or the week after about overtime, you can't call even though we're not talking about it. You call us anytime you have a problem. Anyway, one of the exemptions I wanted to chat about today, the last one, is really the outside sales representative. We get a lot of calls in our office. People are, they work inside and do sales, inside a business. Some of them call us and say, well, I travel and I have a territory, and they're doing outside sales.
So inside sales would be like someone like a car dealer. They
Yes.
work there every day in that building.
Any salesman that works in a building,
Okay.
Electronics store, furniture store, any place, they're inside salespeople.
Okay, and then the outside salesperson would travel to the client.
That's correct.
Okay.
Or travel to try to find a client.
Okay.
So there is a distinction under the law, and inside salespeople typically are entitled to overtime. Now, of course, there is always an exception in the law. That's why lawyers exist. And by the way, let me do a little bit of an aside myself. Shakespeare did not say, the first thing let's do, kill all the lawyers. That is a line in one of his plays. But if you look at the lines before that, you find out what he's doing is he's saying that if you're trying to take over a democracy, the first thing we do, let's kill all the lawyers. Because it's the lawyers that try to keep the rule of law and protect people's freedoms and their rights. So for anybody who wants to keep saying, let's kill all the lawyers and Shakespeare said so, that's not true. I don't have the play in front of me, but that's not true.
You can Google it.
You can Google it.
There you go. Just Google it.
Little interesting factoid. So anyway, so if you're an outside sales representative, in order for the employer to qualify for the exemption, so that they don't have to pay you overtime, your primary duty has to be making sales or obtaining orders for the use of facilities for which money is going to be paid by the client or customer, your work must be regularly and customarily engaged away from the employer's place of business. And unlike some of the other exemptions we talked about, there is no dollar requirement for your salary. You might recall that we were talking last week that most of these key exemptions, administrative, managerial, executive, professional, they've all changed dramatically this year and gone up from a $455 a week salary requirement to, I think it's $913, maybe it's $916, but it's $9 something. Mm-hmm. It's a big jump. There is no dollar requirement for how much you are paid in a salary as outside sales, and there's a good reason for that, is that typically an outside salesperson is predominantly paid on commission. Mm-hmm. I know that very well because, gosh, for I think over 50 years, that's what my father did from one company after another company, trying to find a company that would pay him properly.
Right.
And we get lots of calls from people who do outside sales and do commission sales. They believe that they're not getting paid correctly and somebody's fiddling around with their commissions. So that's a serious issue as well.
Yeah, broadcasting is like that, especially in the sales part of broadcasting. Oh. They may get a small salary, and then they may get a draw.
That's right.
You know, and there's all these different fancy ways for them to get paid, which is why I'm on the air and not doing sales.
That's right. But, you know, there's that key component then again. Your work must customarily be engaged away from the office. And if you have somebody who works both inside doing sales, and then on occasion if, you know, somebody who's stubborn like me says, well, you know, I really can't get there to talk to you and I don't want to do this type of thing on the phone. Can you come to my office and make a presentation before I'm going to do something like ask a lawyer?
Right.
And they come out to my office.
Sure.
Well, if they're just a regular salesperson, unlike the high bureaucracy and officials that I got to meet with, but if they're just a regular salesperson and they typically do their work here inside, they're still going to be entitled to overtime. But if you're typically the outside salesperson going from customer to customer, for example, the people that come and do the yellow pages, you know, in St. Lucie County, we have 3 different yellow pages. It drives me nuts.
Right.
We have what used to be called AT&T Yellow Pages, which I don't even know what it's called now anymore.
The phone company.
Right. Then you have Yellow Book.
Right.
And you have Treasure Coast Directory with the salesfish on the front.
Okay.
And all these salespeople come to my office. They make their pitches and negotiate the contract.
Tell you why you need to be in the book.
Exactly. But they are outside. They travel all over, and they are most likely going to be exempt and not have to be paid overtime.
Okay.
So if you folks out there, or if you know of anybody, or happens in the future, where you're working either inside sales or outside sales, you're paid part or wholly on commission, and you have a question about it, give us a call or give me a call at the office.
No, I understand how when you punch a time clock, how you can prove your overtime. How do you, when you're gone and you're not even in the building, how do you prove you worked overtime?
You know,
because I know them sales girls come back with their nails done and their hair done.
That is an excellent question, and let me try to turn off my iPhone because it is beeping at me. And that still is an excellent question. There we go. I had somebody in my office just this week with that precise issue. Okay. And they were doing work where they were regularly going to different customers. Actually, they weren't customers. They were clients, and they were an occupational therapist. And the question was, well, you know, am I entitled to overtime? Because if I am, I worked a lot of overtime. And we went through the exemptions for physical therapists, occupational therapists, and what you have to do to qualify. Okay. And I said to her, you may very well be entitled to overtime. So I said, on average, how much do you think you worked a week? She says, well, I've generally been working, 12, 14-hour days. All right, that could be a lot of overtime over 2 or 3 years. Mm-hmm. So then the next question is, how are you going to prove it? Well, guess what? I was so surprised and happy when she said, well, my employer has an app that we are required to use. and we sign in when we get to a client's house.
Okay.
We log out when we leave.
Mm-hmm.
We sign in when we start driving to the next client's house.
Okay.
We log out when we're driving is completed. And when we're at home and we have to do all this paperwork for each of the clients we saw that day, we have to log in and log out. So we're going to be able to prove just how much time she was working. And the employer may have a surprise coming soon. Won't say who. But that is a very good question. And let me sort of tell you what the Fair Labor Standards Act says about that. There is, and I think I mentioned it 2 weeks ago, there is no requirement that says how an employer must keep track of time.
Mm-hmm.
It could be a time clock. It could be clocking into a computer. It could be handwritten. It could be written on toilet paper. It doesn't really matter. The only thing is the statute requires that the employer keep track of certain things. And we mentioned the employer's name, social security number, number of exemptions, classification, and of course the hours. Now, how you keep track of those hours is up to the employer.
Mm-hmm.
As long as the employer is able to sustain its burden if challenged, that it had a mechanism in place to accurately keep track of hours, then that's fine. And typically, I want the employer to have something like that when I'm representing an employee. I mean, it's great if they don't, because then whatever my client says is sort of the gospel, unless it's really not believable, and that's because there's an inference in favor of the employee when the employer has not maintained accurate and complete time records.
Mm-hmm.
But I would prefer the employer to have those time records, because when the employee comes to me, some of them have calendars and I've written in how much time they worked, and that's great. I love it when they have that too.
But I could go back and do that today.
It's true, but you're probably not going to go back and do 3 years worth and be able to be very specific.
Right.
There's going to be some patterns of baloney in there. But most people don't have that when they come in.
Mm-hmm.
They can only tell me an approximation. And what I have to do is I have to listen to a fact pattern and use my experience to determine whether or not I find the potential client credible.
Mm-hmm.
If I do, we start with a demand letter, and if that doesn't work, we file suit. Once we're in suit, I have available to me all the tools of discovery. I can start sending out document requests. Give me all the documents that show the time.
Mm-hmm.
I start sending out interrogatories. What mechanism do you utilize to keep track of time? How do you ensure that employees accurately, perform as you've requested in terms of inputting time?
Mm-hmm.
And that gets me the information I need on, did the employer discharge its duty to maintain accurate and complete time records? And it also gets me the information, hopefully, as to what the real time was. Because if I have the real time, not just my client's estimates,
mm-hmm.
and we go into a mediation or we go into a trial in court, there's not much to argue about if it's the employer's time records. Now, it's a little bit different if the employee comes to me and says, I wasn't allowed to put in certain time because my boss said, you're not putting in time over 40. Don't even do it. That happens a lot,
Sure.
honestly.
Yeah. No, I mean, in a part-time basis, I've gone through that where you fill out your timesheet accurately and the bookkeeper goes, we can't pay you for this, and then you get what they decide you should get.
Right, but sometimes it's more sinister. It really is. Sometimes employees are told, don't do this, mm-hmm. or you're going to get fired.
Mm-hmm.
Don't clock in when you first get here. Clock in 15 minutes later after you're getting changed. Don't clock in, for a staff meeting. Clock in after the staff meeting. All these things are compensable time. Required staff meetings, compensable.
Mm-hmm.
If you are required to get into some kind of a uniform, even if it's a McDonald's uniform, if the requirement is to do it at the employer's location, it's compensable time. Mm-hmm. So when an employer will tell you, don't clock in or else, and so you don't clock in, or you don't clock overtime because you've been warned.
Yeah, you go clock out and you keep working.
Right.
Because a specific job needs to be completed.
Then we start looking for what other evidence is there that would support your claims. For example, telephone records. If you've been making calls at 9 o'clock at night from the employer's location and you have your own dedicated line, we're gonna ask for telephone records in discovery. If you regularly utilize a company cell phone, we're going to get the records of the cell phone. If we can show that you made sales and you log the time of the sale, anything that will support your version of the facts in that situation is going to help ultimately a jury, if it gets that far, decide who is telling the truth by a preponderance of the evidence. Or, if it doesn't get to a trial, which is what we hope, and settles, let's say at a mediation, it's going to help the mediator put more pressure on the employer than on you to get a better number. So it's a good question, and it happens quite frequently. But if you've been told, don't clock in or clock out now and stay, and you're listening or you know of somebody like that, don't just automatically assume you have no claim. And don't just assume I can't prove it, so why even bother calling a lawyer?
See, but people tend to just go ahead and go along with it because they'd like to keep their job.
That's right, but the good thing is, if they leave that job, they may be able to get back pay for 3 years. So if you're leaving,
keep good records.
Keep good records, and if you're leaving, call a lawyer. And if you're staying, there's an anti-retaliation provision. That helps. It doesn't stop all retaliation because some of it can be very subtle, but it still helps. And many current employees are willing to come into an attorney and see if they have a case and pursue it while they're still employed. And every situation is different. If it's a place of 3 people and you're working directly for the owner, it may be a lot more uncomfortable.
Right.
If it's a company of 500 people, you may be able to continue working without much interference. So let's talk about quickly docking pay. We spoke that, of course, your pay can be docked if you are a non-exempt employee and you get paid hourly and you're entitled to overtime. And you miss 2 hours, well, the employer is going to dock you for the 2 hours, and that's perfectly appropriate. If you are an exempt employee, typically that means now you're getting paid salary, but you're properly being paid salary. They're not just paying salary to try to make you exempt when you're really non-exempt. If you're really an exempt employee, then the employer cannot dock you for less than a full day's pay. So if you miss a day because you're sick, or whatever, the employer can take that day's pay away and it's still legitimate. If, on the other hand, you have a doctor's appointment and you miss 3.5 hours, the employer cannot dock you because the whole concept of legitimately being exempt and a salaried employee is that you have the discretion and the ability and the trust that you will do the work that is necessary regardless of the hours it takes. So if that means you have to make up those hours to get your work done, you're going to make up those hours. If you don't, I guess maybe you'll get fired or get a reprimand. But no, if you are properly exempt, you can only be docked in increments of a full day. And if the employer makes the mistake and does it differently, they lose the exemption for that pay period, that week. If they do it 2, 3, 4, 5, 6 times, they may lose the exemption with respect to you forever. And then you can go back 3 years. But, once, twice, a mistake, you lose it for that period only. So what about rest periods? You take a break and you have a little bit of a rest. Do you have to be paid for it?
You mean like vacation?
No. I mean like a 10-minute, 15-minute break.
Oh, okay.
If they are short in duration, no, you don't have to be paid for it. Well, actually, I'm sorry. If they're short in duration, you do have to be paid for it. If they are long enough so that you can really do something on your own, longer than a cigarette break, then you don't have
I
to
was
be
going to
paid
ask
for
you
it.
about that.
Yes. If you're getting a quick break for a cigarette break, although I hope as the days and years go by that's less and less,
Yeah.
then you still need to be paid. What about meal periods? Lunchtime. They're generally not compensable. You generally do not need to get paid for that. However, as I think we mentioned, if you do any work during that period, you have to be paid for the whole period. Is that a question?
It is.
Okay. I think we have Brian on line 1. How you doing, Brian?
Pretty good this morning. I just had a question. What's your take on like AOBs and authorization of benefits for if you're doing a job for a contractor or something in that nature?
What kind of benefits are you referring to?
Well, it's for an insurance claim. I work for a company, and the guy had told me that this is just so we can talk to the insurance company. But the way I finally read one, and the way it reads is you're pretty much signing that job to them.
Okay, I'm really not clear on what it is you're asking, so let's try to break it down. You work for an insurance company. What type of work do you do?
I do roofing, but I don't actually work for an insurance company.
Okay.
I work for a roofing company.
Okay, you work for a roofing company, and this question has to do with just benefits or being paid?
Well, the authorization of benefits, when you sign that agreement, is that the actual contract? Or, because to me that means you're signing a contract with that company, and then they're entitled to your insurance money.
Well, again, I'm not sure what benefits you're talking about. Are you talking about
Insurance benefits.
for workers' comp?
No, for say you're getting your roof done, and a company comes to your door, they knock on the door, and they want you to sign an AOB, which is an authorization of benefits, which gives them the right to your claim.
Well, okay, so we're not talking employer-employee. I was thrown a little bit. We're talking basically about, a roofer gets a job, to do somebody's roof. All right.
Yes.
And you're asking if the homeowner who signs an authorization for benefits signs what away?
They're signing the right to their claim if they sign an AOB the way I read it in the paper reads.
All right. Honestly, this is what I would tell anybody who calls my office with a question like that. I would really need to see the document and read it as a lawyer to be able to give a decent answer to that question. You're talking about interpreting a document, and I honestly don't know what it says, or whether, even if it says something, whether it's enforceable. So unfortunately, I don't really think I can answer the question.
Okay. All right. Thank you.
I'm sorry about that.
No problem. Bye.
Okay, that was a little bit confusing at first, but I think I understood by the end what the question really was. And this happens a lot too, and it doesn't just happen in the scenario Brian was talking about in terms of a roofing contract. It happens with employment agreements. It happens with real estate contracts. It happens with all types of contracts, purchase and sale contracts. We'll get a call, and this will apply to any attorney. You'll get a call, and we'll hear a basic description of the situation. And unfortunately, the contract is going to contain most of the answers. And the contract is going to tell us whether, even if something says, well, for example, no, you're an exempt employee. Okay, that's what the contract says. Mm-hmm. But then we have additional facts that could tell us whether or not the contract in that respect is valid. So those are the types of instances where...
Like a non-compete.
Right. Well, that's exactly where we're going. That's typically where we say to somebody, we really have to read the document. Sometimes we'll ask them to send in the document before we say, well, come on in, and this way they're not wasting their time and perhaps even, my time. Mm-hmm. We'll take a quick look at a document and see if we think they may have a claim. If so, we'll bring them in. Other times, some of these contracts could be 50 pages long. And that's a situation where we ask them to come in for a consultation.
You almost needed an attorney before you signed it.
Right. Hopefully, some of them should have had one, and some of them have had one. And some of the attorneys that have drafted contracts have not drafted them very well. But yeah, a lot of times, depending upon your claim, if it's going to be based upon a written document, Attorneys very often are not really going to be able to give you a great answer, even when you call their law office.
Without seeing the
They
document.
can give you some guidance, but at that point, the real answer is going to come in the written document itself. So, travel time, as we really wind down on wage and hour. Travel time to and from your employer's place of business and your home is not compensable. I wish it was. But many employees have jobs where they have to go from one site to another, or they travel from one store to another. That time is compensable. So it is important to keep track of the travel time or the mileage that you're doing from site A to site B and site B to site C, and site C back to the office, but not from the office back to your house.
Right. So
Or-
because you're traveling for that job,
Exactly.
not to get to it.
Right. So
Okay.
that time is compensable, and it's compensable at the exact same hourly rate you get to work. It's a nice drive, nice plane ride, but it's compensable at the same rate. I will see some contracts or those people who don't have contracts, and they come and they tell me, well, the boss said that for travel time, we get 1/2 of our regular rate, and that's how I'm paid. Okay, well, guess what? That employer has just violated the Fair Labor Standards Act.
Now, what if that employee is salary?
Well, if they're exempt, legitimately exempt,
Okay.
then no problem.
Or what if it's all commission?
If it's all commission, if you are properly a commissioned employee so that you're exempt and you're not entitled to overtime, then again, no problem.
Okay.
But if you're a non-exempt employee entitled to overtime, then you have to be paid your regular rate even for proper travel time.
Okay.
I see we have another question.
Well, we have a question, an off-the-air question. They would like your phone number.
All right.
The number at your office.
My number at my office is 772-781-8003. And I'm certainly happy to speak with folks. And usually my paralegal will answer the phone and, take a general basic information, talk to me, and then either she will get back with the caller or I will call if I really need a lot more information.
Right.
And it's easier to do it that way. And then we make a decision both for the prospective client's benefit and our own, whether it makes sense to suggest a consultation in the
So
office.
basically, I can call up and go, "Here's my situation," and you can go, "Well, you really don't have a case."
Absolutely.
And then you didn't waste my time. I didn't waste yours.
That's true, but I'll probably never tell you that you didn't have a case. What I'll tell you is that my impression is that you probably don't have a viable cause of action, but other attorneys might have a different opinion.
Okay.
Because not always, as I say, is it black and white.
So give us that number again.
It is 772-781-8003. And all that proves is that a lawyer cannot speak and write at the same time. I haven't tried the bubblegum test. All right, so now, joint employers. This is coming up more and
Joint
more
employer.
and
So this
more.
is when I don't know anything.
And these aren't employers that provide you marijuana as a benefit.
Not that kind of joint.
No. I got Cliff to laugh. Okay. These are situations in which you are working, whether you realize it or not sometimes, for probably two employers.
Okay.
A good example will be you're hired by a staffing agency. The staffing agency sends you out to, let's say, Home Depot.
Okay.
I like picking on them. I don't know why.
They're big.
And while you're at Home Depot, they set the terms and conditions of your employment, what you're going to
Okay.
do, how you're going to do it.
When you're going to show up.
But your pay is from the staffing company.
Okay.
Both of those are now joint employers under the Fair Labor Standards Act, at least. And that means that they both have potential liability if one or the other screws up.
Okay.
So if you are at Home Depot and you find that you're working overtime and you're not getting paid for it, well, I'm going to be sending a demand letter to Home Depot and your staffing agency. I'm going to be explaining to them the joint employer doctrine, citing maybe apart from the Code of Federal Regulations, to let them know that you are, and I know you are.
Mm-hmm.
And if we have to sue, we're going to sue both of them. So if you're paid by one, or even if you're paid by the other, it really doesn't matter as long as two different entities have some control over your employment.
Mm-hmm.
There are times where one employer may do everything, with the exception of setting your hours, and that's done by the other employer. You get closer then to a situation where the court may not apply the joint employer doctrine. There are usually 7, 8, 11 factors, depending upon, again, whether you look at the IRS test, the Department of Labor test, a test that may be put out by the 11th Circuit Court of Appeals. But generally speaking, a lot of people don't realize when they come in that they really have had joint employers, and that I'm going to go after both of them, because that way they can both talk about settlement and maybe try to split the difference and get my client what we want to get, and it doesn't cost either of them as much as it might otherwise. And if you have to sue and go into court, well, now the jury's looking at potentially 2 deep pockets, and 2 deep pockets are better than 1. So overtime pay, a lot of people have called and they said, well, my employer asked me if instead of overtime pay, would I take an extra PTO day, a personal day off? And I said, sure. I said, okay, well, doesn't matter. The employer violated the Fair Labor Standards Act. You cannot substitute anything for overtime pay. Overtime pay must be paid. Now, if you want to work in additional personal time off or other benefits and modify the regular salary, the regular hourly rate, and an employee says, well, gee, I like these perks and I'm willing to get less money per hour, that's fine. But you cannot force an employee, or as they say, suffer an employee, which really means let an employee work overtime, and then not pay the overtime. You've got to pay the overtime. And that includes if you have a policy in giant letters, in red, in your handbook. It says, no overtime is permitted without the express written permission of the employer. And you work this overtime because either Bob asks you to, or just because you feel in order to finish the work you need to do, and you're being diligent, you work past the time you're supposed to leave. They need to pay you. Now, you violate a policy.
See, now, my theory on that is put it down, finish it tomorrow. Yeah.
That's what probably should be done
Yeah.
if the employer is not looking to pay
well, yeah.
overtime. But the reality is, in those situations, the employer still has to pay the overtime. It can take action against the employee for violating the policy. I mean, it could give you a warning, could write you up, could fire you on the spot.
Okay.
That's okay, honestly. But not paying you is not okay.
Okay.
All right. Employers do some odd things that we see on occasion. One of them is, I made a mistake in the payroll last week, and I paid you too much, so I'm going to take it out of this week's paycheck. Oh, don't do that. You're doing that, you're violating the Fair Labor Standards Act. You are not paying the employee the proper amount for the hours worked in that week. There are other ways to get your money back. The best one being to say to the employee, please write me a check. What do they also do?
What if it's the other way around? What if your check's a little short this week? We'll make it up next week.
Well, that's okay, except the short check for the week that it was short is a violation of the Fair Labor Standards Act.
Okay.
Now, realize that not every violation means you're going to have $1 million case.
Right.
There are violations, and there are technical violations, and I'm speaking here like a lawyer. Yes, it's a violation, and it is. But, the entrance to my office says attorneys and counselors at law. And I take that really seriously because I think they're two different functions. As an attorney, I'm going to tell a prospective client or a client what I believe the legal rights and obligations or consequences are. As a counselor, I may say, forget all that, and let's talk about business reality. Let's say I'm representing an employer, and the employer wants to fight one of these overtime cases because he's right and that former employee is lying through their teeth. Well, I understand your desire to get vindicated. Is it worth the money you're going to have to pay me to get vindicated? Or, unfortunately, is it worth paying something to the employee to try to get out of this? When employers say, no, I'd rather pay you, inevitably we get to a point where they wish they'd paid the employee, honestly. Particularly in situations like an overtime claim where if the employee wins, he's going to get double damages and attorney's fees, for his attorney. So there are situations where I have to talk to people and say, put your business hat on and ask yourself, what would you do as a businessman? Is this a wise expenditure of money? And take off the angry hat. And that happens on the other way around. It happens with employees or just regular folks that are talking to me out of a sense of emotion. And very often it's legitimate emotion. It's anguish, it's anger, it's frustration.
Well, sometimes if you pay a claim, then you almost feel it's an admission of guilt.
That's true. That's why we have settlement agreements that say this is not an admission and it's confidential, etc.
Okay.
I mean, yes, I understand that, but in the end, do you want to pay the employee $5,000 or do you want to pay me $50? As a lawyer, I might say you're absolutely right to defend this case or to prosecute this case.
But it'll cost you more money.
But is it really what you want to do?
Yeah, let's just make this thing go away.
And that's the counselor hat that I wear.
Right.
And usually my clients will listen to me when I put the counselor hat on, especially if I'm arguing against my own best interests. If I have a client who's paying me an hourly rate as opposed to a contingency client, and I can just keep making more money with the more hours I work, and I'm telling that client, stop. It doesn't make sense for you. Look at this and make a decision. Usually they'll listen because somebody who's talking against their own best interest financially, usually you should pay attention.
Yeah.
Okay? On a contingency case, well, if I'm saying you might want to do this as opposed to that, I'm not getting paid unless you get money. I don't know. Maybe you should listen to me. Maybe you should get a second opinion. But generally, the attorney hat is the legal perspective, and the counselor hat is sort of the practical perspective. And now I do have another question came in.
Okay.
It didn't come in on line 1 or line 2 or whatever line it was. It came in from this little gent sitting to my right, and his name happens to be Aaron. And oh gosh, I'm getting past things. Oh gosh, by everybody, even by Cliff. All right, the first question I have here is: what if your boss fires you, and you had worked overtime, but he did not pay you fully for working overtime? They paid you partially. Very good question, Aaron. The employer owes you the rest of that money.
I've been asked to leave, and I can't even get my last check, let alone the overtime.
And that last check is due no later than the next regular pay period.
Okay.
Just so you know. But that's a good question, Aaron. And if you're not paid fully, whether it's regular hours, overtime hours, whatever.
Or even after you're fired.
Yeah, you have a claim. And the good thing is after you're fired, you don't have to worry about being terminated.
Right.
And you have 2 years under the statute to go backwards, 3 years if the employer's failure was willful. We discussed that a few weeks ago. Willful doesn't really even mean I really know what I'm doing is wrong. Willful is simply not following the procedures and taking reasonable steps to make sure that what you were doing was right.
Okay.
So the next question I got, which I don't think is on wage and hour. Oh, my goodness. Oh. Can Stormy Daniels tell her story? by simply returning the hush money. Well,
It all depends on where that money came from.
there might be some first who would say, I disagree with the characterization of hush money. I don't, by the way. But there might be some who would say, before I answer that question, let's put it into a more neutral framework. Can Stormy Daniels get out of the confidentiality agreement and return the $130,000 that Donald Trump's attorney paid on behalf of somebody? We don't know who, really.
My take on that whole thing is if it really came from Trump, the dollar figure would have been much higher.
Oh, I know that's what you think. But people settle for different amounts for lots of reasons. And sometimes you don't want to pay a ton of money. You want to wait for them to come back and ask for more, and then you pay them some more, even though it's illegal. But, doesn't mean it wasn't Mr. Trump.
So you hold it for a different scenario. You hold that bribe money
You may.
for
Because you
the
expect them to come
future.
back again.
Yeah.
But fitting simply with the question we have here, which is, can you get out of the agreement by returning the money? Not always, but here perhaps. Now, what I understand, again, this is from all the reporting agencies, is that Mr. Trump didn't sign the agreement. There, Bulldog! We're going to have to get back to you, Cliff. Bulldog is on line one.
Oh. Okay.
Hello, Bulldog.
Hey, how are you?
I'm
man?
doing good.
I got to get off Stormy Daniels here. Anyway, back to your wages
Yeah.
and overtime. There's been a lot of situations where I've noticed in my business and in many of my associates' businesses, it's natural to work overtime if you semi-like your job, and also to understand the possibility, because a lot of short staffing, and so you got to do it. You've got to make up that time and everything. They don't pay you for it because in your contract is you are to bill no more than 40 hours a week. But shoot, I'd work 60.
Well, now, are you
And
talking
that's
about an employee
regardless.
situation or a contractor that's being hired?
Oh, I was a consultant, so I was hired by some company in New Jersey to go work in Omaha.
All right, so let's
So
go ahead.
and I got hit by the Jersey taxes, not the Omaha taxes, which was where I was physically working. So that got weird. But they also, said I can bill no more than 40, and it was a 6.5-hour road trip back home.
Okay, let's separate that scenario into two branches. The first is if you're really a regular employee, if you're truly an employee, then I don't care what they say. If you work overtime, you're entitled to overtime. If you are a real contractor,
A 1099's a real contractor.
sometimes,
I was a W-2.
Okay.
So
if
that-
you were a
that
W-2,
qualifies as employee
You're
to
right.
a consulting company, if I'm not mistaken.
okay, you're right. If you're a W-2 employee and you are not exempt, then you need to be paid for all the hours you worked, even if the contract says you shall not bill more than 40. Because that contract is still an employer-employee agreement, and it cannot circumvent the law.
I
And-
got to tell you something, man. I wish I knew you several years ago because, I got laid off by these companies as they went through downsizing or mergers and all this other stuff. And I never hired back to that
Right.
company again, and I would have gone after them in a heartbeat.
Oh,
And I
absolutely.
kept
I don't see why nobody would.
everything,
You're
So
entitled to
make
money.
You're making my heart bleed here. I'm like going, oh, man. And it's not that much money, as you would say.
But it's yours.
I didn't book any travel time. I didn't book, it was all drive time because flight time was about the same, and, but I
Well,
didn't book any of that.
Sometimes it pays to call a lawyer to even get a question or two answered. Really, if people out there, whether it's you or anybody else, aren't sure about something, Googling is great, but sometimes you can save yourself a lot of aggravation and pain down the road if you just quickly talk to a lawyer. Lawyers should not be somebody that are called, only when emergency surgery is needed. Sometimes you just need to go to the doctor.
When you're in trouble.
Yeah.
And here's another thing, that may help a lot of other listeners too, is that I would imagine if you worked for XYZ plumbing company, and what they do is a lot of times they'll contract out, or they'll have contractors work for them,
Right.
not real employee, something like that.
Well,
and if they've got travel time to the job site and things like that, that's all billable time, or it should be.
We have to be very careful as to, in those situations where, for example, it's a general contractor who is contracting with a subcontractor. That itself is not an employer-employee relationship. So if the general contractor enters into a contract with a subcontractor that says, we're going to pay you $3,727.33 for this job, that's what you're getting paid.
Oh, right. But I'm saying is a lot of times, the actual people that they bring on are W-2s, and, they're basically outfitted with their own equipment and everything, but they're not technically, employees.
Well, lawyers pay a lot of term to that technically.
Yeah.
You could be a W-2, but maybe you're really an independent contractor, or more often you're labeled an independent contractor and you're a W-2.
So, more like a 1099 on them, and then you're at quarterlies. So,
those are important distinctions, and
right.
That's why lawyers look at it very carefully.
Yeah, exactly. So, what an employee is and how it's defined under the contracts are interesting, and I found it different state to state every time I hired on.
There are different definitions of employee and employer depending upon what the issue is. When you're talking about wages, you have a federal statute, and while states are free to provide more relief than is available under a federal statute, they cannot provide less relief. It's part of our federalism system. If there's something that is appropriate for the federal government to legislate and they legislate it, then the states are obligated to follow it, although they can give more. There are states that pay $15 an hour for, hourly wage now. There are cities that pay $15 an hour for hourly wage. There's a move towards paying this kind of an hourly wage. That's not the federal minimum wage, but you're free to do better than what the federal government requires. You just can't do less. So I think before we end up closing, I'm going to try to go back to Cliff's question, Bulldog, and I hope I answered yours.
Well, thank you
very much
again
for
your
calling.
Time, sir.
All right, you're welcome. All right, Stormy Daniels. Supposedly Donald Trump didn't sign the contract. Is that important? It can be, and it might not be.
Well, the question is then who did?
Nobody signed on behalf. It's blank.
Oh.
Okay. So sometimes that's important, sometimes it isn't. In this situation, if the contract is only giving benefits and obligations, responsibilities, duties in one direction, let's say to Stormy Daniels, and she signs it, and she accepts the benefit of that contract, she may not be able to get out of it simply by saying the other party didn't sign, because there's no real significance of the other party not signing when they paid. The signing, they had no obligations. Now, if you have a contract where there's a mutual general release, I release you and you release me, and one party doesn't sign, you can probably get out of the agreement by disgorging the benefits that you've received and saying it wasn't a proper contract. So I'm suspecting that there were some obligations on behalf of Trump or the mystery identity person who this really related to. And if there were any mutual obligations, then the failure to sign is not as significant. If she disgorges the money and is able to otherwise give back, whether it's tangible or intangible, any benefits of the agreement, she can probably get out of it. But it really depends upon the rights and responsibilities of the parties, whether or not both signatures are critical. There are a lot of respects that one signature is not critical, and so a lot of times we'll have, an agreement that's supposed to be signed by two parties, and I don't really care if my client signs it because it's the other side that's paying all the money. And so if they don't sign it, let the other side remind me a year from now, your client didn't sign it, can you please have them sign it? But on the other hand, if they don't sign it, I'm a little bit worried. Mm-hmm. So I hope that answered your question. There's been a lot of argument about that on all the different networks, and they get into all these esoteric theories, but it really boils down to the rights and responsibilities under that agreement. And how do you figure out what they are? You've got to look at the agreement. And if the agreement is not available to these pundits, then you can give these generalizations, but you cannot really opine on the specific instance at hand. Mm-hmm. Now, it looks like we're not going to get to non-competes this week.
Darn.
But that'll be the entire topic for next week.
Okay.
We're just about to close out, but I got one more question from the 8th grader here who is hopefully going to graduate and head into high school. And he says, what if you take a short break, you don't check out on your time card, and you get into a situation where you have to be transported to the hospital? Noting you still haven't clocked out, how does your employer pay you if you haven't clocked out? Well, that's a very good question, and it does happen. And in that situation, the only obligation is to take reasonable steps to determine when the employee ceased to work. And you fill in the time clock manually.
I would have to hope if I'm being hauled away in an ambulance that they pay me for the whole day.
Well, one would certainly hope, and it wouldn't surprise me, though, if they don't. I represent some very good employers, and I have represented some good employers. But on the whole, I do represent employees, and I hear the horrible stuff. Looks like we're out of time.
That would be just terrible to be hauled off ill.
Thanks for listening. This is Ask a Lawyer. Tune in next week at the same time, 10:05. And if you have any questions, my office is 772-781-8003. Have a good day, folks.
This is WPSL Port St. Lucie, the talk of the Treasure Coast.